Please be seated. Proceedings are resumed. I acknowledge the fifth elected member from the District of Georgetown. Continuing your debate.
Thank you, Madam Speaker. Can I
I'm
confirm the
reliably
time?
informed by the clerk that you have 54 minutes remaining.
Thank you, Madam Speaker. Madam Speaker, where I left off was I was about to go into Mr. Ian Paget Brown, QC's speech to the Grand Court at its opening on the 16th of January 2013, and I arranged to have a copy placed on your desk, Madam Speaker, so you have the same document now. Madam Speaker, again, Cayman Finance said that this was the first time to their knowledge, even though they had a number of lawyers on their board, this is the first time these things had been raised. Madam Speaker, I will talk about some of the comments in his address to show otherwise, but I'm also going to talk about the things, again, that he said that we as a parliament nor the government have really taken on board. And when I go through some of the letters that I will read to this honorable house, we'll see that those situations still exist. So if we're not the people who deal with it, who will? Madam Speaker, on page 3, in the role in legal practitioner's law, Mr. Paget Brown, QC, says as far back as 2007, the Law Reform Commission was instructed to look into the issue of amending the legal practitioner's law to enable practicing certificates to be issued to non-residents working in the law firms abroad. He goes on to say, we were told that if the law was not amended, Cayman firms would have to close their offices in foreign jurisdictions where they were employing people who did not hold practicing certificates. The Law Society and the Caymanian Bar Association, in their meetings with the Commission, represented that if we did not amend the law to allow overseas practicing certificates, the island's financial industry would be severely impacted to its detriment. Acting on those representations, the Commission prepared a report and submitted draft legislation to Cabinet. The view taken at that time was that if there were strict rules of professional conduct that applied to both resident and non-resident attorneys, the court should be able to regulate attorneys practicing overseas. Madam Speaker, the sky was falling in 2007 as well. Subsequent governments did not or could not address the situation. He goes on to say that at a cabinet meeting attended by representatives of the Commission, the Law Society and Caymanian Bar Association, I was asked what impact I believed allowing non-residents to be admitted would have on the prospects of young Caymanians. I answered that they would be affected by any amendment to the legal practitioner's law that widened the class of people who could become Caymanian attorneys, because there would be less incentive for law firms to hire and train Caymanians to staff the foreign offices that would be needed to comply with the existing law. Madam Speaker, again for the record, I support foreign offices that carry out these important functions for law firms. But they do so now in contravention of the law. And I think, and this is my personal opinion, not anything I'm quoting from this paper, is that a lot of this surrounded what was perceived to be a detriment to Caymanian attorneys and also the fees that were involved. And we have a chance to do that in this bill, but it has to be a balance, it has to be fair, and there has to be some acceptance that this was, in fact, a breach of the current law. Madam Speaker, I'm going to skip forward and address again what Mr. Paget Brown said was, or has his heading was History of the Legal Profession on page 7, Madam Speaker, a little bit more than halfway down the page. He said, "It seems to me that there is a perception amongst lawyers that they are the ones responsible for the success of the Cayman Islands. To that, I can only say that it was Cayman that made the lawyers successful, not the other way around." He goes on to say, Madam Speaker, skipping to the last paragraph on that page, "Our loyalties were to Cayman first and the common good of the people of these islands. We treated ourselves as guests and behaved accordingly. We felt honored to be a part of Cayman's success story." Madam Speaker, continuing on page 8, he raised the topic of discrimination. And he started out by saying, "But it appears that things have changed. It is evident that many in this community consider the social injustice experienced by some of their best and brightest compatriots even more troubling than the outsourcing issue. The Caymanian may well ask herself what is or was the point of devoting years to educating herself only to find that there are no real opportunities to pursue the career she has invested so much effort and made such personal sacrifice to prepare for. How can this situation be right when there are so many non-Caymanians practicing Cayman Islands law without being admitted as Cayman Islands attorneys? Thus, it follows that perhaps a very important objective of the new law is to ensure that bright and ambitious Caymanians have legitimate opportunities to fully participate in the legal profession without having to compete with those practicing as Cayman Islands lawyers illegally. There is an urgent need for the profession to address law school scholarships, articles of clerkship, hiring opportunities, equitable distribution of billable work, marketing and networking exposure, attendance and contribution to conferences, being mentored, mentoring and training others, continuing legal education, work experience overseas, and preparation for and participation in leadership and ownership of offshore and local firms. Madam Speaker, this has to be done. That is the roadmap right there. Those are all the things that you would be looking for in an equity partner in a firm. We just don't put our people through the paces in a systematic way. A lot of times it's luck of the draw. That should not be happening in 2017. He says in the next paragraph, it is lamentable that the legal profession has made it necessary to consider some sort of affirmative action instead of creating reasonable opportunities for Caymanians to share in the prosperity that this jurisdiction has afforded so many expatriates over the last 4 decades. Madam Speaker, at the bottom of page 8, and this is the part that we didn't take notice of, this is the part that we didn't address. There is a feeling among Caymanian lawyers that the major law firms are in the hands of people who don't care about the islands or where work is conducted. They have no real interest in living or investing in these islands, prefer that the business of the offshore industry be conducted elsewhere to avoid the immigration and work permit regime, have established a glass ceiling operating to the detriment of Caymanian professionals, give Caymanian professionals inadequate and unequal training. There are unequal opportunities for Caymanian advancement within the firms, and a system has developed over the years that is designed to ensure that Caymanians fail, have created an environment of fear and victimization, preventing many Caymanian professionals from speaking publicly, and in opposition of the firms. Being a team player is synonymous to Caymanians having to rat on Caymanians who want to see the profession become fair, transparent, and accountable. Some contend that only foreign lawyers reap the economic benefits and successes from the offshore business, and that when the firms get a chance, they outsource jobs, suggesting that the firms have no loyalty to these islands. The evidence shows that Caymanians are deliberately being marginalized in the workplace, denied fair opportunities to advance, have been instructed on occasions about how to vote at Caymanian Bar Association elections, told that to be a team player, they must allow the status quo to continue uninterrupted, used as pawns to secure status grants and permanent residence, and once the Caymanian has outlived his or her usefulness in securing those grants, they are unfairly and constructively dismissed. There are allegations that firms may have been guilty of filing misleading affidavits, qualifications, residence, experience, character with the court, misleading the Trade and Business Board as to Caymanian participation and efforts to secure it, failing to report Caymanian applicants, misleading the authorities as to the nature of experience and qualifications as to both expatriate and local applicants, publishing misleading advertisements so to seek to avoid attracting qualified local applicants, giving misleading description of the positions held by Caymanians and expatriates for regulatory advantage, concealing remuneration for regulatory advantage, failing to make applications for promotion/redesignation, and disingenuous about the nature and extent of training, taking on article clerks but then not offering employment opportunities, and in-house training programs that are not offered to Caymanian. Madam Speaker, this is someone who's a QC, Queen's Counsel, for those who don't know what that means, and 42 years standing in this country as a lawyer. Madam Speaker, no one responded to that in earnest. When you hear these types of allegations that I've just read, and no one at least says the person that's bringing them is totally wrong, no one says these are things that we need to look into to see if they are right, and we just ignore them. Madam Speaker, that is why we're standing here today talking about these issues, because people either put their head in the sand and ignore them, or they did not come out and say they were hogwash. Either way, Madam Speaker, we needed to ask the question. If someone makes these type of allegations in such an auspicious setting, we need to take note and either accept and act on them or get out behind it and say they're totally false. Nothing happened. Madam Speaker, when we were doing our research and we were speaking to Caymanians, in September 2015, people would not come forward, not to put their names down at least. Madam Speaker, I've given my copies to get copies for the entire house because, again, like I said before when I started, I want that. So I'm just borrowing a letter from one of my colleagues. But Madam Speaker, Madam Speaker, I think this next letter that I'm about to read, and which again I've asked for copies for everyone, and I know that the Honorable Premier was copied in on this, and it was forwarded to both of us at the same time. But this, Madam Speaker, shows, and maybe it was appropriate that this debate started yesterday on International Women's Day. Maybe it's because these people are mothers of Caymanian children. But it's the women that have led the way in putting their names behind the letters and saying, you know what? I'm a Caymanian. I need to be heard in my own country. Madam Speaker, this brave young lady is stepping forward. And she probably knows what this means. But it shows to me that people are now willing to step forward and to speak their minds in their own country.
Honorable member from Georgetown, have you obtained consent from the said person to disclose her name?
I have, Madam Speaker.
Okay.
Madam Speaker, the letter is actually addressed to Honorable Alden McLaughlin, Premier, and it's entitled the Legal Practitioners Bill. And it starts, the level of misrepresentation in the public discussion regarding the Legal Practitioners Bill has risen to such a level that I feel it appropriate to share my experience as a Caymanian attorney with you. It is fundamentally wrong to suggest that Caymanian attorneys do not have issues with the terms of the LPB or with the current conduct of certain law firms. The reality is that most of Caymanian attorneys are the principal breadwinner in their family, and therefore, in the current absence of proper regulation and absent a properly competitive employment market for Caymanian attorneys, are effectively beholden to the firms they work for and do not speak out because they feel that their career prospects would be prejudiced by doing so. This is a vicious cycle because the principal issue that Caymanian attorneys encounter is restricted or unequal career progression. I was someone who used to think of other Caymanian attorneys who raised objection as complainers or people that weren't working hard enough. That was until I experienced such issues personally. I graduated from the Cayman Islands Law School in 2003. Having graduated from Loyola University in 1997 after studying economics. I undertook my PPC at the Cayman Islands Law School, receiving the University of Belfast, Ireland Practicing Certificate, Cayman Islands Law, after which I completed my articles with OJ. I was admitted as an attorney in the Cayman Islands in 2005. I stayed with OJ after being admitted as an attorney until I moved to Maples and Calder in January 2008. As of January this year, I had 12 years post-qualifying experience, and I had been with Maples for 9 years. I worked as an associate in the Cayman Funds Group. I worked in key client relationships and consistently met the high financial targets set, save in respect of 2013 and 2014, when I had been absent on maternity leave and subsequently had to rebuild my practice, which had been reallocated among other partners and associates during my absence. In January 2015, 5 foreign attorneys were promoted to partner in the Cayman Funds Group. These included people with 9 and fewer years PQE, only a portion of which would have been in the practice of Cayman Islands law, and as little as 2.5 years' time with the firm. I applied for partnership effective January 2016, at which time I was told, at which time I would have been 11 years PQE, and that's the post-qualification experience, Madam Speaker, and I'm going to use the PQE from here on, and would have been with Maples for 8 years. I was told that it was felt that the financial performance of the Cayman Funds Group did not warrant additional partners at that time. I appeared quiet in my progression application interview, and I would benefit from an additional year with an equivalent track record under my belt. I felt this was unfair after the commitment I had shown the firm, particularly so given the large number of foreign attorneys promoted to partner the year before, but took them at their word and worked towards my partnership application for January 2017. It is worth noting that the process at Maples requires that you be invited to apply for partnership. This is effectively a pre-qualification, as your proposing partners are stating that in their opinion, you satisfy the requirements of the position and should be made a partner. I was proposed on both occasions by John Fowler, Global Head of Funds, and Nicholas Butcher and Jonathan Green, the respective Cayman heads of funds at the time of each of my applications. I also received positive comment in respect of my application for partnership from other partners I had worked directly with, including Paul Govier, head of the London office, who I had worked with on matters for a number of years, including a period in the London office, and Tim Frawley. These are the partners I had worked most closely with, and who were therefore best placed to assess the quality of my work and contributions to the firm. In December last year, I was advised that my pay for the forthcoming year would not be increased because I was at the top of the salary band for associates. And the bonus I would be receiving was also not to be increased from the prior year. The last salary increase I received was in January 2014, so this would have been my 3rd year without a salary increase, despite the rate which the firm charged clients for the work undertaken by me having increased over this period. I responded to the effect that this reaffirmed my view that I should have been progressed from associate to partner previously, and that all things considered, I would not be minded to stay with the firm on such terms, but I regarded it as not directly relevant because my anticipation was that my partnership application would be considered favorably. In January this year, however, I was advised that for a 2nd year, my partnership application had not been approved. I was advised by John Fowler and Jonathan Green that this was due to macro issues. They specifically stated that it was not due to any failure on my part. They did, however, volunteer comment that my statement that I did not intend to stay with the firm if I was not progressed, which I had stated was because I would view my failure to progress this year with a higher PQE and longer service with the firm than foreign lawyers who had been previously made partners, as an indication that Maples is not somewhere where I would progress, as a threat. And that it had not assisted them in getting the approval of 18 of the 24 equity partners globally that was required for the application to be approved, none of which equity partners were Caymanian who qualified locally, as such term is used in the draft legal practitioners bill, and none of whom were women. After years of thinking of Caymanian attorneys who raised objection as complainers or people that weren't working hard enough, I realized that the rules were not fairly applied. So I resigned from Maples and I'm currently serving out my notice period. After submitting my resignation, Jonathan Green advised me that he was very disappointed and offered me a few weeks during which I could reconsider. Leaving aside the patronizing aspects of his comments and the fact this was offered in addition to me having been invited to apply for partnership on 2 occasions, supports the fact that my contribution was equal to the foreign attorneys in the firm. I believe the circumstances outlined also evidence that Maples does not have regard to its obligations under the immigration law, save perhaps for filling out submissions in a manner that make them look compliant. The macro issue I was principally dealing with is that Maples, in advancing numerous foreign attorneys in the years prior, was not having regard to the effect that such promotion and redesignation would have on the opportunity for advancement to the level of qualified Caymanians already engaged in the same profession, as required by Section 51B of the immigration law. I understand that since my resignation, work undertaken by me has been redirected to one of the work permit holders who was made a partner in 2015. This reflects that the work I had been dealing with was partner level. But as opposed to the work of a Caymanian attorney being consolidated into the practice of an underutilized salaried partner on a work permit, the intention of the immigration law is surely the reverse. And given on 2 occasions I had been pre-qualified to make application for partnership and had made such applications, I question that when it comes to renewing the work permits of such persons, whether Maples properly complies with the terms of Section 44(5) of the immigration law, which provides that a person who, when making an application under Section 42 of the board or to the chief immigration officer, willfully A, withholds information that a Caymanian, the spouse of a Caymanian, or the holder of a residency and employment rights certificate has applied for the position for which a work permit is sought, or B, provides inaccurate or incomplete information with respect to paragraph A in an attempt to deceive the board or the chief immigration officer, either by act or omission, commits an offense and is liable on summary conviction in respect of the first offense to a fine of $20,000 and to imprisonment for 1 year, and in respect of the second or subsequent offense to a fine of $30,000 and imprisonment for 2 years. In addition to which, Section 4.1 of the immigration regulations require that an employer or prospective employer should use all best endeavors to ascertain whether or not there is a Caymanian or a person legally and ordinarily resident in the islands, ready, willing, and able to undertake the job in question before making an application for the grant or renewal of a work permit in respect of a worker or prospective worker whose gainful occupation in the job is sought to be authorized by the work permit. And Schedule 3, subsection 3 of the immigration regulations provides the business staffing plan submitted for the purposes of paragraph 2 shall contain the following information concerning the business. E, in respect of posts held by work permit holders other than permanent residents, the likelihood of such posts being filled by Caymanians or permanent residents and the anticipated length of time in respect of each post before that happens. Maples appears to consider its partner appointments to operate outside the scope of the immigration law. This view is supported by the text of a draft commitment that Alasdair Robertson, in his capacity as president of the Law Society, proposed to be given by law firms earlier in the process of seeking support for the Legal Practitioners Bill, which provided that every responsible firm would ensure that the minimum criteria which needed to be met by an attorney for progression to partnership and the time scale associated with such progression are applied equally to all attorneys at law in the relevant jurisdiction and practice area, and are communication to all Caymanian attorneys employed by the responsible firm, with the objective that Caymanians in any jurisdiction and practice area can be reasonably satisfied that they are competing on a level playing field with their non-Caymanian peers. Aside from the fact that my own experience did not accord with this, the draft notably failed to recognize that suitably qualified Caymanians should be preferred over work permit holders in the Cayman Islands, in addition to which it continued. It must be stressed for the avoidance of doubt that the nature of partnership means that the judgment and decision as to whom to appoint as a salaried or equity partner must remain with the relevant firm in accordance with its constitutive document and procedures. The fact that Alistair Robertson would see fit to put forward a draft commitment that provided that the appointment of partners by law firms, which in the case of Maples largely comprises salaried partners who are employees with the job title partner, operates outside the terms of the immigration law, tends to support the assertion that this is the manner in which they have habitually operated. I have no confidence in the provisions contained in the Legal Practitioners Bill regarding the progression of Caymanians when the president of the Cayman Islands Law Society proposing them also happens to be the global managing partner of a firm acting in this manner at the same time. Should they not be seen to lead by example? That is particularly so when under the current draft Legal Practitioners Bill, by being able to direct the votes of the large number of lawyers with the firm, Maples and others that are like-minded would have almost certainly controlled the composition of the council that is intended to supervise such matters, in the same manner as they currently do the Cayman Islands Law Society and Caymanian Bar Association. The Cayman Islands Law Society and Cayman Finance have sought to cast the independent MLAs as causing unreasonable and harmful disruption. The alternative perspective is that firms such as Maples are ignoring their existing legal obligations and have put forward draft legislation that is so unbalanced that people with a proper understanding of these matters feel it necessary to raise issue. This alternative perspective has been recognized previously, including by Ian Paget Brown, chairman of the Law Reform Commission, as long ago as January 2013, which he stated, "It is lamentable that the legal profession has made it necessary to consider some form of affirmative action instead of creating reasonable opportunities for Caymanians to share in the prosperity that this jurisdiction has afforded so many expatriates over the last 4 decades. The people who have sought to bring attention to current practices and issues with the draft Legal Practitioners Bill should not be blamed for doing so. The issues they raise should be addressed, and it is of concern that government has been supporting the draft Legal Practitioners Bill in its current form with apparent greater concern to the discrete interests of large multi-jurisdictional offshore law firms than the interests of Caymanian attorneys. Yours sincerely, Anna Gabo. Carbon copied, the Honorable Anthony Smelly, Chief Justice, Honorable Samuel Bulgen, Attorney General Winston Connolly, MLA.
Member, you have 21 minutes remaining.
Thank you, Madam Speaker. And I've been reliably informed, Madam Speaker, that the Honorable Chief Justice has already responded to that letter. Madam Speaker, I could stay here for about 2 days, but I think that letter of that brave young woman, because let me tell you, in this honorable house, she has just marked herself for career suicide. But it shows that Caymanians have had enough. This has been going on far too long, and we as leaders need to address it. We need to address it here and now. Madam Speaker, You are a former lawyer yourself. No doubt some of these issues are not new to you, but they're also not new to any of the lawyers in this room and many of the politicians in this room, because people have been coming to them over the years, over decades, saying a lot of the same things. It's time we put on the role that we were elected to do and have some serious conversations with the legal fraternity. No longer can we accept our people being blackballed for speaking out. No longer can we accept Caymanians not getting fair and equitable training and advancement opportunities. The time is now, Madam Speaker. Not tomorrow, not in the next, after the next campaign. The time is now to show this country who its leaders are and what we were elected to do. We don't have to let the sky fall, but we have to have those serious conversations, and it has to be a compromised conversation. Madam Speaker, I won't get into the technical aspects of this bill until committee stage. But there will be significant amendments proposed to this bill. And Madam Speaker, we went out to industry, right? After we had heard that the majority of Caymanian Bar Association members supported this bill. We did our own surveys. We spoke to people that came forward and helped look over this bill, because I'm the only lawyer on this side of the pond. They were forthcoming. They were very adamant in one thing: this is not a balanced bill. And if the government brings this, they're going to have to answer to those people up there, Madam Speaker, those people outside. Madam Speaker, bear with me 1 minute. Madam Speaker, in a theme, and I'm not going to read this one in its totality, right? But you'll get the gist. Again, another brave young Caymanian, well, I'm assuming young, but I'll say Caymanian attorney, wrote to the Honorable Chief Justice on the 17th of February this year. And the person wanted to bring attention to certain matters relating to the bill. Issue 1, the exemption from the Local Companies Control Law. Section 71 of the bill seeks to introduce that the Local Companies Law does not apply to our company. That lawyer said, "My concern with respect to this issue derives from my understanding that law firms in Cayman take predominantly one of two forms: a partnership or a company incorporated practice." He goes on, or the person, I don't know if it's a he or she, sorry for being gender specific to he, but they go on to talk about the rationale. And I won't go into all the details. The second one was the foreign practice certificates. And Madam Speaker, this is part of the parcel that I'm giving everybody in the House, even though this was circulated to all members of the House as well. But I will say that this person was not as confident as the writer of the last one, because we have a redacted letter, so they didn't use their name. But what was important was that there was a response from the Lord Chief Justice to say that this should be raised in Parliament, right? And there were important matters in this letter. Madam Speaker, and I also want to use my remaining time to publicly acknowledge someone who I didn't know before this process, who immediately stood up and spoke out about this bill. Madam Speaker, I think that when history is recorded, that young woman, again, should be recognized as that first brave soul that came forward and penned her name, notwithstanding whatever consequences would come thereafter. And maybe again, it's because that person is a mother of Caymanian children. But she went through carefully and meticulously and represented her views, her strong views on this draft bill. And when I read that letter, Madam Speaker, because I was really contemplating what role I would have in these discussions. Because I've always said, Madam Speaker, that I want to go back to my family at some point in time, and I wouldn't be here for the long haul, so to speak. But while I'm here, I'm going to represent my people the best way I know how. I had said in the past, publicly, that no matter where the role as politician took me, after 2 terms, I was going back to help raise my children, that my wife has unfortunately become almost a widow in terms of time, and to be back with my family. And so, Madam Speaker, with that in mind, I know at some point in time, I want to go back to also having a job. And Madam Speaker, I was wondering how forceful I would be in that. Would I represent my true emotions, or would I kind of temper them and really not show my continued abhorrence of what I consider discrimination and inequity of opportunity? Madam Speaker, this brave young lady wrote a letter, and she stood up at a meeting prepared to be the coronation of this bill, because we were supposed to be coming to the House the very next day. And her voice shook, and she spoke out passionately, eloquently, and sounded like she was a lot older than the person I ended up meeting afterwards. Her name is Miss Selena Tibbetts. She should be recognized as the first person brave enough in this whole ordeal that didn't have the obligation that I do in this honorable house to stand up and talk freely. She copied that letter to every single member of this honorable house, Madam Speaker. Madam Speaker.
You have 11 minutes remaining.
Thank you. I think that these things are serious enough that people who have in the past been reticent to put their names to their concerns and their fears and everything else, that if they did that in their role, in the profession that they're in, knowing what the ramifications are, at the very least we can do is take notice and address them. In this honorable house, and really look to see whether or not we can put in reasonable sections of this law to get it to the CFATF standard, but take the time that we didn't do before that to really sit down and go through this bill and ask ourselves two questions. Is it good for Caymanians? Is it good for the Cayman Islands? In that order. And I bet you, Madam Speaker, if we took the time, some of us would change our minds. Madam Speaker, I could go on. I could actually also speak about the Caymanian Bar Association. Madam Speaker, when I look at emails from that association to me in the past, when I look at memos going to the Immigration Board, and again, Madam Speaker, that's in the package. I don't know where it is. I asked for it by 2:30, but it'll show up and other people can take it forward. But to have them be silent at this stage, right at the moment that this bill is supposed to be in, and not raise the same issues about the concerns about immigration, etc., again, and they did so as late as July 2015, I think there is a travesty there. They are not carrying out their mandate, and I can understand some of the reasons why, but it also then shows that the composition that exists right now has failed Caymanian attorneys, and it needs to be looked at and corrected. That is the body that's supposed to be representing Caymanian lawyer interest. It is not. And if we allow that to continue and the status quo and reward bad behavior, then we are complicit in this whole thing, Madam Speaker. We need to take a critical look at where our people are at, why they're there, ensure that they have equality of opportunity, and if they're deemed competent, if they're deemed able and capable, we follow the letter and intent of the immigration law in its entirety. Not seek to take out bits and put it in and talk about equitable progression. If you are a Caymanian lawyer in the Cayman Islands and you've done everything asked of you, you should be preferred. The fact that you're not getting to equity shows something is wrong in the ladder that you're climbing. So either it's the education or it's the training and exposure. It's something. If the accountants can do it, we surely can do the same. Madam Speaker, I do wish I had more time.
You have 6 minutes remaining.
Thank you, Madam Speaker. But I'm just going to speak now in the last 6 remaining minutes that I have to the Caymanian attorneys, to all those brave souls, and I'm going to ensure that my promise to you is kept. Those letters will be read in this House. I've run out of time, but I'm passing them on to my colleagues because someone is going to hear your story, not the fluffed up.
Member, please keep your comments through the chair. I know the temptation is great, but...
Thank you, Madam Speaker. It's just that some of the lawyers were in the room, but I understand and I will comply, Madam Speaker. So I apologize for that. Madam Speaker, the amount of attorneys that wrote to me anonymously shows that there is a culture of fear that exists that we need to tackle head on in this honorable House. The fact that people have also, this time around, penned their names and have allowed us to use their names is also powerful, Madam Speaker. But it shows that Caymanians, who are normally very passive-aggressive people, have had enough. Rights must, we know what right and wrong is, and right has to win out, Madam Speaker. And anyone in this House that chooses to ignore its people, they pay the price in the end. Thank you, Madam Speaker.
Does any other member wish to speak or recognize the Honorable Leader of the Opposition?
Thank you very much, Madam Speaker. Madam Speaker, this very important bill has been pushed to the front today, and it's a pity somehow we couldn't debate the bill and the motion that has been tabled and given rise because of the bill, the Legal Practitioners Bill. It is causing serious concern all around, and no one needs believe that there is not debate in the homes of the Cayman Islands about this matter. It is. It is causing serious concern all around for various reasons. Concerns from professional Caymanians coming to me. Madam Speaker, I don't support the bill. The fact that there are 136 amendments by members on this side and more to come, and I understand 60 odd from the government, I must say that gives me much more reasons not to support the bill. Here we are, Madam Speaker, and I know what they will probably say when I sit down. On the 11th hour, before this House is prorogued or dissolved, and we think that we will get it right. We've got to have that confidence in ourselves. But, Madam Speaker, we know that we won't get it right. There are some areas, Madam Speaker, that should be acted upon. The implementation of the Code of Conduct, for instance. If there is need because of FATCA for the area the minister spoke about, then let's do so. Although, Madam Speaker, I think we have sufficient regulation all over this country in all laws in place already that should sufficiently satisfy FATCA if there is reasonableness by them. I hope I'm not misreading or misunderstanding what the minister said, but that's what I thought he said, that there were some provisions here that had to satisfy FATCA. Which one then? What? Ah, yes, all them same thing. All them is that over-regulating our country to the extent that we can't do anything much. Yet, and I've said so many, many years ago. I said so in Ottawa. I said so when OECD met here. They are not complying themselves, but are fast giving us regulation piled upon nearly every bill that we have, every law that we have, so to keep us much more and much less uncompetitive. I would, Madam Speaker, rather have had the opportunity to sit down with the minister leading or whoever the spokesperson is for the draft of the bill, went through the problems of the industry and the added problems of the removal of the proverbial glass ceiling, which is a huge complaint. We then, Madam Speaker, could have called in the people affected and there come up with a solution to what is causing the problems the industry is facing and our people need and want to be addressed. So, Madam Speaker, I will, as I have tried to be with this matter, balanced. There is the owner, there is our people who are affected today and those of the future. There is international business that we must be careful not to chase away. These are my considerations. The financial industry, which is dependent on a robust and efficient legal system, is responsible for producing just, I guess, well over 50%. Some people say 53, some people say 49, but it's a big part of Cayman's gross domestic product and employs numerous Caymanians directly and many more indirectly. There is agreement in the industry that the present legal practitioners' law and regulations need to be brought into the 21st century, and the bill makes an effort so to do. However, there are provisions in the bill which seems to have not been considered sufficiently and are likely to significantly impact the provision of legal services in the Cayman Islands and have adverse effects on the economy and the employment of people here. These provisions should be revised, and as I said, I don't know what the amendments are. I understand that there are 60 odd from the government. Maybe those will get passed, and the 136 from this side and more might not. I don't know who relish sitting down at this late stage to try to think through. With only knowledge that we have is what is going to come from the government bench and some from the side who are legal people. But I would say that I would have rather had that bill in committee room and sit down with people, and not just lawyers, because this bill and the motion is going to affect across the board. That's what's going to happen. And I would have rather done that rather than have to sit down in formal committee, as I said, to do what? To listen to the people that have brought the bill and to work from my understanding and what others have told me, rather than I repeat, to have sat in the committee room and brought people in. And then once that was done, we would come out here and we would have had our say the same way, and all the input that we had in the committee would have been addressed out here. I would have rather seen that. Madam Speaker, the provision that requires attorneys who are coming to work in Cayman Islands to undergo a period of apprenticeship, and I don't know if that can work, and they have to pass some type of exam. I think it's going to be expensive for all. And no one need not think that any cost incurred by law firms is not going to be passed on. It's going to be passed on. And so, Madam Speaker, the majority of this House might feel that that is necessary, not me. There are provisions in the bill which relate to the temporary admissions of attorneys for specialized cases. And we need to ensure that there is a knowledge transfer to our local advocates, Madam Speaker, and that should be accepted by law firms. We know, Madam Speaker, that our legal industry and the financial industry, because of the various types of business we conduct, is heavily dependent upon highly experienced and qualified attorneys who specialize in various areas of law to represent clients in our courts and so on, and is proven to beneficial to Cayman and the legal profession over many, many years. But these provisions need further clarification as far as I'm concerned. I know there are provisions in the law which seriously impact on the ability of firms to have offices outside of Cayman. Cayman is an international financial center, and nearly all the business which the financial industry derives is generated from a global industry outside of Cayman. The limitation of the ability of firms to operate in areas and markets which can and do generate business for the financial industry would be a very negative development and will affect Cayman significantly going into the future. That's my opinion too. Other players in the industry, though, just for example, the United Kingdom and the United States have significant presences in financial centers such as Hong Kong, London, New York, Paris, Beijing, and so on. And of course, other international financial centers who compete for the same business in Cayman do not impose limitations like that, as far as I understand. Madam Speaker, we are sensible enough to find a way to help our people, our young lawyers, get business without going some of the routes that I see. Routes that we do not know what is going to be the reaction of the industry, which we as lawmakers do not now and probably will not ever control. Madam Speaker, some of the things going on and some of the actions that wants to be taken was taken by a country that caused Cayman in the late 1960s to pass our first trust laws. That country is still reeling from the flight of capital and business back then in the 70s. And so we do need not believe that we can't be so impacted. And some of the things, the expectations that I see on the blogs and social media, I have to wonder if they ever stop and thought for a while. I said many, many times, and I keep saying, Cayman is not the only girl at the ball. And we need not believe that we cannot be negatively impacted by some of the frustration and the belief that we are not accountable to the people that we expect to get business from. That's not so. We are. And I don't need to be told by anybody that if I can't have it, then nobody else can have it. That's not so. At least not in my books. There are provisions which cross over and seek to legislate matters which are provided for under the immigration law, for instance, Section 76 of the bill. Also, Section 62(3) of the bill appears to me to be unconstitutional. In its present format, it seeks to incorporate certain parts of the proposed law in such a manner that the legislature, the Assembly's legislative power, is limited. And I think that is unconstitutional. For example, the section provides that unless a contrary intention appears, the section applies despite any provision to the contrary in any other legislation, whether enacted before or under this section, comes into force. In our system, Madam Speaker, Parliament cannot pass a law which a future Parliament is unable to change. Never heard of it. So, Madam Speaker, the regulatory regime under the bill and the cost of the same, most of which do not belong, as far as I'm concerned, in a legal practitioner's law, would make it virtually impossible for Caymanians who qualify as attorneys to set up their own firms. Need much more thought. I know the minister. I see him smirching out there. Huh? If you talk to me, talk so I can hear you. And I don't read lips. If you got something to add to my thought process, then do so, please. No, I know that. I know you can wait till I sit down, right? No, okay. Madam Speaker, I'm not talking to him. I'm talking to you. I'm told, Madam Speaker, that whilst lip service is paid to issues of concern to all Caymanians, the firms they represent have done precious little to ensure a diversity of some kind of partnership in those enterprises. And why this remains the position since the law regulating the practice was passed in 1967 certainly defies some rational explanation, but certainly that's the way young Caymanian lawyers feel. And we've just heard the matter being read by the last speaker from a person who was so affected. But I can tell you that something is radically wrong when numbers of people come to my yard dressed in cap, in a hat, in a coat, and I saw them coming through my gate, and I don't know them, but they are doing so because they do not want anybody else to identify them. That they come into my yard to talk to me about this matter and the motion. And there's concern on all fronts about the two. Something got to be wrong. And I can't help but feel that why in the world, and a Cayman is free, as we say, we are, that people have to be so afraid. But it is. It's over the past several weeks, in fact, not so much when the bill was first talked about, but since the presence of all these articles in the paper, people, because they know the frustration. We in this house, we know frustration from what we have to put up with. Well, they work in the industry. They feel it. Now, is all of them right with all the complaints? Because you know, once one start, there's all sorts of things being brought to fore. I don't know. I don't work in the industry. But I have to be enlightened by those that do. And they say that the problems exist. Madam Speaker, from the perspective of the general public, why does any of this matter? Because, Madam Speaker, the public policy objective of the original law and the establishment of what is now the Truman Bodden Law School of the Cayman Islands, namely the creation of a local cadre of experts across all disciplines of the law, has been continuously frustrated by the failure of some of the larger law firms to ensure that qualified Caymanians have the opportunity to progress to having a partnership stake in those firms. They feel, Madam Speaker, that outsourcing has a negative impact on them. That's what I'm told. In the currency of the debate, Madam Speaker, over the bill, the larger firms have failed to take up the opportunity of electing qualified attorneys to full partnership positions. And those lawyers feel in some cases these eligible Caymanians have been bypassed for promotion by individuals who have less experience. They say, Madam Speaker, that there are well-documented instances of discrimination and abuse. That's what they say that go on in this country. And that's why when they come into my yard, they are dressed up like a John Canoe. And as recently as 2016, Madam Speaker, a lawyer on work permit felt able to advise in correspondence an experienced Caymanian attorney to refrain from utilizing pidgin English in a letter. And Madam Speaker, lest it be thought that I'm going overboard, this incident did not happen, and they feel that it did not happen. Well, the expatriate lawyer was dismissed following that disturbing incident, which was reported to the Honorable Chief Justice and the Honorable Attorney General. He was dismissed. These abuses and discrimination have been somewhat documented publicly, also by the Queen's Counsel, who was mentioned by the last speaker, the fifth member from Georgetown, and not a single law firm. And when I read it, and I waited to see what was going to be said by the larger firms, but not a single law firm has ever contradicted or challenged his findings on those issues since he presented his report to the Grand Court in 2013. Nobody. In my thinking, Madam Speaker, there is no Also, no public policy justification for law firms to be absolved from Caymanian part ownership requirements where they are capable and willing to work. Accountancy practices with world-class Caymanian partners, Madam Speaker, do not appear to have a problem with the desired approach. So perhaps someone can explain to me, why should law firms? Embarking, I think, on this course is not tantamount to nationalization, as the minister has said, of law firms. While these law firms are privately owned, Madam Speaker, giving appropriate promotion cannot be counted as
Honorable Minister
nationalization.
for Financial Services.
Just on a point of order, Madam Speaker.
Please state your point of order.
The member is indicating that I have said that applying LLC provisions to law firms was a nationalization. I didn't say that, Madam Speaker.
What did you say? Maybe you can say it, and I'll pull it back.
Madam Speaker, I have been referring, all I have said publicly is that my perspective is that I want to see the legal industry Caymanianized as opposed to nationalized.
That's good enough for me, Madam Speaker. You may be a lawyer, but you can't dig that hole so small that I can't see through some of it, you know. It had the same meaning, as far as I'm concerned. He might say it away. I don't know if you want to take it out of the Hansard or whatever, Madam Speaker. The fact is, what he said meant the same thing to me.
Honorable Leader of the Opposition, I think he was trying to make a distinction between nationalism and Caymanization. I'm just saying what the minister stated. I obviously can't interpret your perception of it, but as a matter of fact, he's saying that he was referring to the Caymanization rather than the nationalization. So if you could use that word, and if you're not going to use that, and say it's your opinion.
Well, Madam Speaker, I have to agree with you. It is my opinion. But, Madam Speaker, as I said, nothing here is being nationalized. Because I believe in sensible nationalization, but I don't want to practice anything else. Not in Cayman's economy. But if that was so, then the result, the accountancy firms are equally nationalized without any discernible negative consequences because they are Caymanized. They are. I think, Madam Speaker, everyone who wishes to be admitted to practice Cayman Islands law should be subject to the same licensing regime required of locally qualified attorneys. Madam Speaker, the present policy means that some law firms often resort to employing junior overseas attorneys with no experience of the Cayman Islands law. And I'm told that the practice is to the proven detriment of junior Cayman qualified attorneys whose services become redundant when an expatriate attorney is employed locally. Madam Speaker, just recently, this month, I believe, a local young man was given the articles some time ago, but when he completed them, they wouldn't give him a job. The law firm that gave him the articles would not give him a job. Yet, the same law firm got permits for 3 inexperienced foreign lawyers. So it means that the 3 lawyers don't have any more than 3 years experience and should be considered very junior. And Madam Speaker, that seems to be happening or has happened far too much. These are some of the reasons that I can't support the bill. And so, these public policy problems, though not exhaustive, Madam Speaker, should be sufficient for all legislators, regardless of party, affiliation, group, independent, whatever they want to call themselves when they're reading. I belong to a party. Should cause us all, though, to pause and reflect, at least I do, that indeed it must require each and every legislator to demand detailed explanations from the Law Society and the Cayman Bar Association. We should not be beguiled by advertising, which seemingly asserts the bill is needed so as to modernize the practice of Cayman Islands law. As demonstrated, Madam Speaker, the problems of practice are systematically larger than the assertions put forward, they painted up or varnished, or assertions put forward by the organizations. Furthermore, Madam Speaker, when these organizations truly reflect the views of the local Caymanian attorneys, it's very much open to doubt, given the number of, I said, private complaints to me. Madam Speaker, at the end of the day, if the desire to modernize is genuine, the larger law firms do not need a law to do the right thing by qualified, willing, and able Caymanian attorneys. These law firms, without any legislation, have long possessed the power to invite their Caymanian colleagues to the front of the bus. Caymanian colleagues who work hard and produce for the firm ought to be given the push to the front of the bus and be a partner of some kind. And now everybody can be a partner, I don't believe, but obviously there's much, much to be desired. Those that work hard, because, Madam Speaker, even as we here want to see our people get ahead in a law firm in Cayman, competing with international firms in every country we try to get business from, our lawyers, Caymanians, and expatriates must be able to produce, because mediocrity cannot cut it. Given the failure that I knew a few days ago, even to the extent of taking that young man on, what assurance can legislators gain that by passing the bill, things will change? If these firms are so desperate to modernize, they each could, at a stroke of a pen, Madam Speaker, rid themselves of the ancient practice of maintaining this impenetrable glass ceilings that exist. Certainly, the time has now come for legislators, conscious of our duty to the public and to future generations, to require that each and every publicized, grievance is addressed before any further consideration is given to the bill. That's my position. Certainly, I don't consider these advertorials in the press or letters who say they are written voluntarily by article clerks proclaiming support of the bill. Too many come to me to say that's not so. These steps, as far as I'm concerned, is but a cynical ploy to gloss over the inherent defects of the bill and the concerted effort by proponents to cement the current status quo, which, from what is being told to us, is discriminatory and even abusive. I would hope, Madam Speaker, that the accusation about being abuse is people who perhaps I just got to the point of saying that they are abused, that is abusive. But certainly, from the people that come to me, it's discriminatory. And if we take a stand now, the sky, Madam Speaker, will not fall in. Will not fall in. Madam Speaker, I think we have that duty to stand up. And I know some people have said. I had one on Facebook telling me the other day all sorts of things, making all sorts of accusations. Say he's a lawyer too. I don't think he's stable though. Madam Speaker, I really don't support the idea that we bring a bill and there are already 136 amendments from this side and more to come, and 60 odd from the government. I don't consider that is the way to proceed at this hour. There is no good to say we must do it at this stage and do damage that we do not envision. And 3 months down the road, damage is already done to the industry and to more people's lives. Can't happen. They can't tie anybody's hands. No legislation can do that. And, Madam Speaker, for all these reasons, the bill is opposed.
Does any other member wish to speak? Does any other member wish to speak? I recognize the fourth elected member from the District of Bordentown.
Thank you, Madam Speaker. Madam Speaker, I also am rising to contribute to the debate. on a bill for a law to repeal and replace the legal practitioner's law. Sorry, Madam Speaker. Just trying to get organized.
Speaker, if I may.
Honorable member from Easton, do you have a point of order?
No, Madam Speaker, there's a gentleman walking around in the seating upstairs. And I don't know why, because there must be some decorum. One must sit in a chair when they arrive in the gallery. Could we please find out why he's walking around?
Sergeant, you've heard the request. Please investigate and report back.
That I'm not worried about, but Madam Speaker, the gentleman has been in here quite a few days and he's just walking around. I don't know why that is.
The sergeant will check and report back. Fourth elected member from Bordentown, please continue.
Thank you, Madam Speaker. Madam Speaker, I can feel with the member from East End because these days we have been a little bit on edge for reasons reported previously in this honorable House. I think that's a good place to start, Madam Speaker. Madam Speaker, I know there's been a lot of discussion locally about the statement I read last week in this honorable House about concerns that members of the independent opposition were being followed and so forth. I think those issues have been well ventilated in the press and all the places. Madam Speaker, I'd like to begin by reading a text message that we received, but I have omitted any names, local names. But the request has come to me to provide some further details, and I will go on as far as I think is permissible, as I know that the police are still investigating. So, Madam Speaker, member of the independent opposition received this text last week, which says, Lawson Consultancy employed by blank and blank. I've omitted the names. They are declaring all-out war against Winston and Arden. No limit on money or method to get them out. They hired some people to follow them and dig up dirt yesterday. Please advise them pronto they're going to need help. Madam Speaker, under normal circumstances, we would have probably dismissed that. But we heard the Honorable Attorney General yesterday give an argument that the Minister for Financial Services was at liberty to declare a conflict of interest or not, or clear himself of any conflict of interest. And because of the ethical standards that he operates under, he, as a lawyer, it was acceptable that we should give him some credibility and respect his standing as an officer of the court. Madam Speaker, this text message came to us from an officer of the court. And that is why we took it so seriously. That individual has been interviewed by the police and has confirmed sending the message. I won't identify the individual. However, the individual stopped short of identifying who asked them to pass on the warning. And I will only say that much, Madam Speaker. So I brought this thing to the public's attention last week, and I wanted to bring it to a conclusion that despite what people are saying, we know what is at stake here. We know that this path we have chosen has created us a great deal of, a large number of enemies, and there are individuals who will stop at nothing to stop us. But Madam Speaker, like my colleague from Georgetown, I am resolute. I am determined to see this through to the end. The government has the numbers. The government can go ahead and vote this bill through. But they're going to do it without my support, unless I see significant changes in this bill come committee stage. But Madam Speaker, that is just to give an idea of what we have been dealing with. And as I said, the information came to us from a lawyer, someone who we should give the benefit of the doubt as well. And we took the information seriously. Madam Speaker, I have yet to see the amendments that the government is putting forward. I don't know if they've been circulated as yet. So I will hopefully be pleasantly surprised when I see those amendments. But I would like to also table the results of a survey conducted by the independent members in relation to this bill. I know there's been some question as to how this was conducted and so forth, but it was done through the same process that the survey done by the CBA was conducted. We used the same software, and we sent our survey out to the email addresses of all the Cayman lawyers that we know. So I think that while it may not be 100% scientific, none of us are statisticians, I think that the results are reliable. And I'll quickly step through the questions that were in the survey. And just to give you an idea, Madam Speaker, of the type of responses we got, it was in the region of 100 people. So the first question was, do you believe that the Legal Practitioners Bill as drafted is an immense improvement that promotes and protects the interests of Caymanian lawyers? In our survey, Madam Speaker, 30% said yes, 70% said no. Okay, so out of 110 respondents, oh yeah, that's much better. 33 said yes, 75 said no. Next question, do you believe that the CILPA Council, as constituted with 3 of 8 members being Caymanians, will promote the qualification, training, and development of locally qualified attorneys to equity partnership? 105, I'll circulate a copy. I got limited time, so I'll circulate a copy. Okay, fine. I'll keep going till you stand. Do you believe, okay. So the question was, do you believe that the CILPA Council, as constituted, with 3 of 8 members being Caymanians, will promote the qualification, training, and development of locally qualified attorneys to equity partnership? 105 people responded, 25 said yes, 80 said no. How do you rate the level of Caymanian representation in the management/partnership of law firms? 104 people responded. 73 said poor. 22 said could be better. 7 said acceptable. 2 said excellent. Question 4. What percentage of equity partners and shareholders in Cayman firms are locally qualified as defined in the LPB? 95 people responded. 43 said less than 1%. 30 said less than 3%. 22 said less than 5%. Question 5. What percentage of locally qualified lawyers should be equity partners in major law firms in order to better reflect the wider Caymanian society? The average answer was 42%. 90 people responded to that one. Question 6. Do you believe that law firms in Cayman have followed the immigration law by properly hiring, training, and promoting able, capable Caymanians to equity partnership in Cayman law firms? 102 people responded. 11 said yes. 91 said no. Question 7. Should law firms be subject to the trade and business licensing law, local companies control law, like accounting firms currently are? 107 people responded. 72 said yes. 35 said no. Last question, Madam Speaker. Do you believe government has adequately represented Caymanian lawyers' concerns and interests in the drafting, circulation, and education around the Legal Practitioners Bill? 107 people responded. 23 said yes. 84 said no. Madam Speaker, I will table this so that all members can
So ordered.
have a copy. And I apologize for all the paper, Madam Speaker. Madam Speaker, compared to the accounting industry, I think that the current equity participation by Caymanians in the legal industry pales by comparison. And we keep hearing the question, how many Caymanian trained equity partners are there? How many Caymanians, locally trained, locally qualified, have become equity partners in, say, the last 10 years? This bill, Madam Speaker, expects its council, the council that is being created, to provide a system of legal education to facilitate the entry of Caymanians into the legal profession and provide for a mechanism to deal with professional misconduct. The same individuals who drafted this bill, Madam Speaker, we've heard numerous examples from previous speakers, are also being accused of holding back Caymanians. I really don't think, Madam Speaker, that it would be wise for us to entrust the future of this lucrative industry that is already riddled with problems in the hands of the same individuals that are being accused of mishandling it. Madam Speaker, I really don't think that this is the future that the architects of our financial services envision. To me, it represents an attempt to hijack a very lucrative industry and use the government to further what I consider selfish selfish goals and ideals. Madam Speaker, who are these 180 people that we are being asked to grandfather into the system? Can anyone stand up and confirm that these individuals are indeed qualified to practice Cayman law? Have they passed the tests in their home jurisdictions? Can anyone vouch for them other than their bosses? Madam Speaker, in not supporting this bill, I am not advocating for any sort of affirmative action. I believe that Caymanians can compete and perform with the best in the world. I have worked in the legal industry, and individuals, the Caymanians that I work with, could compete with anyone. So that is not my main concern. But Madam Speaker, we need to level the playing field. And as I move on into my debate, Madam Speaker, I will explain a bit more about what that means and why I don't think this bill does it. So, Madam Speaker, in the same way that the lady lawyer whose letter was read by the 5th elected member from Georgetown, the same way that she may be committing career suicide, I am not willing to let her do that on her own. She's going to have my support, and I will continue to defend the rights of all Caymanians, and especially in cases where I see what is being attempted here. I'm going to fight strenuously, even if I have to do it on my own, Madam Speaker, because I am no stranger to what has gone on in our financial services. And while we need to be responsible, we need to advance our country, and we need to promote our country. Madam Speaker, you cannot come to the altar and be saved and baptized unless you admit to your sins. So it's time to seek atonement. I will support this bill if I see significant changes and amendments, Madam Speaker. But I am not willing to just wipe the slate clean and pretend that the discrimination and intimidation of decent, hard-working Caymanians didn't occur. I refuse to do that, Madam Speaker. I was elected to represent those people. The law firms and anyone else who is supporting this bill may see that differently, and they may think that the politicians need to come in here, Madam Speaker, and support this bill to promote their businesses. I am here to promote Caymanians. And I know I'll be accused later on of posturing and looking to get votes. Madam Speaker, I know the fight that I'm up against. I know what is going to be thrown at me. I know what's coming, and I'm going to face it head on. We all bleed the same blood, Madam Speaker. So all I have to say to them, bring it. It won't be boxing this time, though. I might get charged with assault. Madam Speaker, I do have to commend the 5th elected member from Georgetown. I think he did an outstanding job in presenting his opposition to this bill. And I think he's been quite truthful in his presentation. And I think that he has adequately represented the concerns that have been brought to us. And I want to thank him for voicing the concerns of those many Caymanian lawyers who have to suffer in silence, Madam Speaker, and who are not able to speak up. And I know that some of them have been criticized for not speaking up, Madam Speaker, but I honestly believe that individuals like myself, the other members of this opposition bench, were elected to do that, speaking up for them, and to take that fight on for them. That's our job, Madam Speaker. I don't expect every single lawyer to sacrifice their career or put their career on the line. They have livelihoods to worry about. They have families to take care of. And I think this is our responsibility to take this fight on as representatives. So I don't blame those that have not stood up and spoken out. They speak to us quietly, and as the Honorable Leader of the Opposition said, Madam Speaker, they sometimes come a little nervous and apprehensive, but they do come. And even when situations such as the one presented last week come to us, Madam Speaker, I could very easily stand here and start to name names and say who told me what and how I knew what was going on, but I'm not going to do that. I'll take the licks for it because I believe those people deserve our protection as well. If people are so brazen as to threaten members of this parliament, you can imagine what they would do to someone who didn't have privilege. So, Madam Speaker, I really don't think that we can support leaving the future of our financial services in the hands of those who I think have been a bit reckless with how they've managed it in the past. We need regulation, Madam Speaker. There is no argument about that. But self-regulation by these same players, I think, is a bit dangerous. It is a case of the fox guarding the hen house. Madam Speaker, I question how much consultation was actually done across the board, because we kept hearing that the bill had the support of 75% of the entire industry, or the two. Yeah, of the associations. But I've spoken to members of those associations, Madam Speaker, who hadn't seen any sort of communication, any sort of draft bill, and did not get an opportunity to participate. I want to know, and I hope the minister will answer this, how widely this bill has been circulated, or at least the draft bill. Was it only to the executive members of the CBA and the Law Society, or was it the entire membership? I'm talking about during the drafting stage, prior to the consultation. Madam Speaker, I think it is quite clear that those individuals who have the power, the influence, will look out for those that they consider that they are familiar with and identify with. And when this bill talks about facilitating the entry of Caymanians into the legal industry, I really have to take a step back and really wonder about that statement. The entry. At this stage in our development, Madam Speaker, we shouldn't be talking about entry. We should be talking about the advancement, but not entry. We should be looking at this stage to further progress and advance Caymanians. Madam Speaker, looking at some of the other clauses in this bill, I'm looking at the definition of qualified law firm, which means a firm that undertakes to practice Cayman Islands law in the islands and has at least one attorney who is Caymanian. It only needs to have one single Caymanian partner, which, Madam Speaker, means that Caymanians will not have voting control in that firm, or potentially could not have. The same criteria can be used to control affiliated offices, Madam Speaker. And I think there is too much potential. I don't see any groundbreaking change here. There is too much potential for the status quo to remain. What benefit do we get, Madam Speaker, from putting members on the council that will regulate Cayman Islands law and our legal industry who have not been here long enough to even earn Caymanian status? I can't think of too many other boards, Madam Speaker, tasked with promoting the interests of Caymanians that can have a majority of non-Caymanians as part of the membership. In what is being proposed through this bill, Madam Speaker, all attorneys, even those overseas, can vote on the makeup of the council. This definitely gives those larger firms with overseas offices a distinct advantage, Madam Speaker. The larger firms, Madam Speaker, will have more influence. And I think the only way to mitigate this is by allowing more Caymanians within that makeup. Madam Speaker, we have to question who is it that we're building this industry for. If it is not for Caymanians, then why are we doing it? I really don't see anything in this bill that jumps out at me and says this is for Caymanians. What I see in this bill is that this is for the law firms. We really need to take a look back, a step back, and examine, Madam Speaker, why we are here. I am not here to promote anybody's business. That's supposed to happen naturally once the government creates the right environment. However, I don't support doing that on the backs of Caymanians. We all need a piece of the pie, Madam Speaker. We all need to share in this Caymanian dream. And we all deserve to be treated fairly, especially those of us who were born here, grew up here, educated here. Why is that such a bad thing to say? Why do I draw criticism for promoting the interests of Caymanians? So that's all I'm doing. And maybe the minister will get up and say that a lot of these concerns have been addressed. However, I have not seen any amendments, Madam Speaker. So I am speaking to the bill that was presented to me. As I said earlier, I look forward to those amendments in the hopes that they will improve this bill. Madam Speaker, if at this point we are not working towards requiring majority Caymanian ownership in our firms, in these law firms, then we at the very least need to ensure that the regulatory body, the council, is made up with majority Caymanians. At the very least, let's make sure that the gatekeeper is made up of locally qualified Caymanians. I don't see any reason why that can't happen, Madam Speaker. And that's not affirmative action. That is simply demanding that your people have a place at the table and are in control. We have to start believing in ourselves, Madam Speaker. We can't continue down this road of Caymanians are not ready, we're second best. Caymanians are ready to take control of our future. And the only way that will happen is if the government promotes that. So let's not offer half a solution. Let's trust and believe in each other and move forward together. Madam Speaker, looking at the requirements for being admitted, I note that I think it's on the 1st of January 2019. Up until that point, you must have 3 years PQE. And beyond that, it must be 4. I would ask the minister to explain when he winds up why we're waiting until 2019 to implement the 4 years. Why not just do it now? I know already what will happen. This is stacking the odds in the favor of the firms again. This is stacking them against the Caymanians. Make it immediate. I know there are no shortage of foreign lawyers with 4 or more years PQE, but it seems to be putting another barrier in front of Caymanians and will allow the importation of more competition for our Caymanian lawyers. Madam Speaker, Section 34, 3B speaks to the supervision of lawyers with less than 5 years PQE. And that section suggests that the supervising lawyer should have no less than 5 years PQE. So I'm just asking for clarification on that. I'm not criticizing it. I just want the minister to explain why the difference. Because it would seem to me that you're saying that 5 years PQE is the standard.
Honourable Member, we've reached the hour of interruption. I recognize Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, I move the suspension of Standing Order 28-2 in order that the business of the House may continue. Sorry. 10-2 in order that the business of the House may continue beyond the hour of interruption.
The question is that Standing Order 10-2 be suspended in order for the business of the House to continue beyond the hour of interruption. All those in favor, please say aye.
Aye.
Against, no.
No.
I believe the ayes have it. Accordingly, Standing Order 10-2 has been suspended. Fourth elected member from Bordentown, please continue.
Thank you, Madam Speaker. And looking, Madam Speaker, looking at locally qualified lawyers in the bill, and this is the first time I'm seeing the distinction between locally qualified and not locally qualified in the law. And I know a lot of people will draw similarity between potentially indigenous and non-indigenous. So I am hoping, Madam Speaker, that that won't become another complaint down the road where locally qualified is viewed as not quite so good as not locally qualified. And I wasn't quite clear on why that distinction was being made, because I don't see any huge benefits being attached to being locally qualified. If you were doing this to promote those lawyers who were locally qualified, then I could understand that. But it creates a difference between the two types of lawyers. And I fear, Madam Speaker, that it will be used for anything other than the good of Caymanian lawyers. It will not benefit them. But we also can't forget that some Caymanians get their legal qualifications overseas as well. Madam Speaker, Clause 32 of the bill talks about serious professional misconduct, but also recognizes professional misconduct. And I'm also wondering why have the two levels. As far as I am concerned, Madam Speaker, misconduct is misconduct. So what is the purpose of having that distinction there as well? I hope one won't be applied to locally qualified while the other one doesn't. And then looking at applications for limited admission of foreign counsel, Madam Speaker, the bill will allow foreign lawyers to apply for admission to practice in Cayman on a temporary basis. And I understand that from time to time this may be a requirement, but Madam Speaker, you only need to be out in front of the courthouse on any given day, and you see an abundance of non-Cayman lawyers entering that courthouse, Madam Speaker. And I think already there are complaints in the industry that work that could be done by local lawyers, locally qualified lawyers, is being farmed out to lawyers from other jurisdictions who come in here in these temporary arrangements. And the Caymanian lawyers get the crumbs that are left on the table after they get the majority of the work, after they get the lion's share. I think even the Honorable Chief Justice, Madam Speaker, has commented on this, on the fact that local lawyers can do much of this work. So, again, making a specific arrangement for this practice to continue, I think will hurt the smaller firms, the sole practitioners. And I think the wording of that needs to be looked at. Madam Speaker, Section 68(1), and I'll read it except with the approval of the council, a qualified law firm shall not permit non-Caymanian attorneys to practice Cayman Islands law in another jurisdiction with a qualified law firm or an affiliate of the qualified law firm if A exceeds B plus C plus D, where A equals the number of non-Caymanian attorneys who practice Cayman Islands law in another jurisdiction with the qualified law firm and any affiliates of the qualified law firm. B equals the number of Caymanian attorneys who practice Cayman Islands law with the qualified law firm and any affiliates of the qualified law firm. C equals the number of non-Caymanian attorneys who practice Cayman Islands law with the qualified law firm and any affiliates in the islands. And D equals the number of trainee attorneys employed by the qualified law firm and any affiliates of the qualified law firm. Madam Speaker, the way I am reading this equation, in my limited legal experience, it seems to be that what we're basically saying is that someone on a work permit has equal weight to a Caymanian. I don't think, Madam Speaker, this incentivizes Caymanians, and it flies in the face of our immigration regime, which rightfully so says that Caymanians must have preference if they are qualified. I see this as part of an attempt, Madam Speaker, to undermine or get around our immigration regime. And I think sections like this being in this bill, Madam Speaker, will hurt more than hamper Caymanians. More than help. And I do note that it states that the council says except with the approval of the council. So it seems as if the council has the final say, not cabinet. And I think this trumps the immigration regime that we've set up here. Madam Speaker, section 73. A law firm may apply to the clerk of court for an annual operational license on a form approved for that purpose by the clerk, accompanied by the fee prescribed by the cabinet, being a fee calculated by reference to the number of attorneys at law in practice with the law firm, subject to a maximum annual fee in respect of any one law firm of $400,000. Madam Speaker, I don't understand why we are capping this or capping it at such a low level. It is no secret, Madam Speaker, how much money these firms make. And I don't understand why the law seeks to limit government's revenue in this way. Why not just leave it open to the number of attorneys? Leaving millions of dollars on the table. I mean, we've already heard the estimates of what has happened in terms of lost revenue from work permit revenue for people practicing Cayman law overseas who technically shouldn't be. So now we're putting provisions in this bill, in the law, that caps government's earning potential. As these firms grow, they make more money and put more strain on government's resources, but government is limited in the revenue that it can take in, Madam Speaker. I don't think that makes good business sense. Well, I'm sure the Honorable Premier will correct me when he gets up. Okay. Perhaps this will help clear it up, Madam Speaker. I think this is self-preservation. This bill was drafted by who? Not government. Things like this have been put in here. They certainly don't benefit the government. Only the government is going to lose in that equation, Madam Speaker. I think so. Have we examined, Madam Speaker, the financials of all these firms? Do we have an idea the tremendous amount of money that they make? Are our fees, are the government's fees based on a good understanding of how much money is made in our legal industry? These firms all rely on government for services. Why shouldn't government be a partner in that whole arrangement? And I mean a partner in terms of at least getting its fair share of the revenue as well. I think it's a logical question. I can't hear you though. But we're capping potential revenue. Yeah. That doesn't make it right that it's in all the laws. This is the, Madam Speaker, I apologize. I shouldn't be cross-talking, so I'll get back on track. You think so? Madam Speaker, Clause 76. The purpose of a business staffing plan that complies with this part is to ensure that when recruiting staff, a law firm accepts a commitment to provide opportunities to Caymanians. 76.2. A business staffing plan of a law firm shall make reasonable provision to give Caymanians access to the legal profession, including training and development and subsequent equitable progression within the firm. Madam Speaker, I really hope the minister explains the term equitable progression to me, because the way I read that, it's saying we're treating Caymanians the same as we treat a work permit holder. That's the way I read that. And again, I'm accustomed to an immigration regime where Caymanians get preference if they're qualified. So I don't understand why this bill seems to be trying to work around that. I'm not a lawyer, Madam Speaker, but I try to apply a little bit of common sense to these things, and the way that reads to me is opening a door that we don't want to open. I think it's a giant leap backwards, considering the letters being read here today, Madam Speaker, and the stories being told by our own lawyers. Equitable progression. Madam Speaker, the bill defines partner as a person who has entered into partnership in accordance with the partnership law. I think that definition is quite narrow. And partners are not related to law companies. So perhaps some people will get the idea that firms can transition into law companies. I don't know, I'm just speaking out loud and asking the questions, Madam Speaker. It might be a way of circumventing this whole process if you're a law company. Law firms, Madam Speaker, use the term associate partner when applying for work permits. These associate partners, Madam Speaker, perform very similar roles to partners, but pay a lower work permit fee. As it stands, Madam Speaker, the government is currently being cut out of hundreds of thousands of dollars in work permit fees, and it seems to me that this provision is seeking to continue that. because of the difference between salaried partner and associate partner in the law. Madam Speaker, the makeup of the council, I think, underrepresents the smaller firms. The sole practitioners, I think, are severely underrepresented. And I know that based on what I have read in this bill, the mid-size and the larger firms will have a distinct advantage over the smaller firms. And while to some that may seem quite natural, it is the smaller firms that we should be giving some preference and priority to. They're the ones that need the opportunity to grow. They're the ones that need the most assistance. So creating a council that is biased against them, I don't think will help them, Madam Speaker. Madam Speaker, the council's composition does not give the single practitioners a voice. There are many, many single practitioners who are not going to get the representation that they need on this council. The bill says that the council must have at least one locally qualified sole practitioner as a member. I haven't seen the amendments. If the law is to represent the entire spectrum of practitioners, Madam Speaker, no, fine.
Madam Speaker,
Honorable Minister for Financial Services.
just on a point of order, and I don't want to make a big deal of it, but the member is misrepresenting what the bill says in terms of the composition of the council. There will be 2 members of the council prescribed by the bill who will be representing
Can you refer me to this section, Minister? Page 33.
Madam Speaker, just in terms of the composition of the council, which is prescribed by clause 11(3). Madam Speaker, and I'll just read through it. Madam Speaker, further to subsection 1 and 2, One moment, Madam Speaker.
Madam Speaker, maybe I can help clarify this. I think I said that the council would have, sorry.
Can we, can we just have one member standing at a time?
All right, Madam Speaker. Madam Speaker, Clause 11, 1 reads, there should be a council of the association called the Council of the Cayman Islands Legal Practitioners Association, which shall consist of 8 members, who shall be attorneys at law with the qualifications specified in the rules. Subclause 2 says the members of the council shall be elected in accordance with Section 7(2)(c). Subclause 3 says further to subsections 1 and 2, for an attorney at law to be a member of the council, the attorney shall be ordinarily resident in the islands and practicing Cayman Islands law in the islands. B, at least 2 members of the council shall be attorneys practicing Cayman Islands law in law firms with fewer than 10 attorneys. C, no more than 2 members of the council may be practicing Cayman Islands law with the same law firm. And D, at least 5 members of the council shall be Caymanian, of whom at least 3 shall have qualified locally. So, Madam Speaker, the point was that there was a reference to sole practitioners being represented on the council, when in fact the council talks about, or the composition described here talks about firms with less than 10 attorneys. There is no reference whatsoever to sole practitioners being represented as a separate body. And that is just the... And I think, Madam Speaker, there was an earlier reference to the majority of the council being foreign lawyers, which again, clearly by reference to this provision, was inaccurate.
For elected member from Bordentown.
Madam Speaker, I think then, based on the minister's clarification, it's worse than I thought. There are no sole practitioners specifically stated in the composition of the council. It says firms with less than 10. Those are not sole practitioners specifically. No, it could be 9. So what I would like to see is it could be 3, is a provision here that those sole practitioners, one lawyer, have a voice on this council. So I think, Madam Speaker, the situation has got worse. I'll withdraw the earlier one if it satisfies everyone. Yeah, so do I.
Please continue.
Thank you, Madam Speaker.
Remember, the clock is ticking. Don't
Yes, ma'am.
allow your time to be usurped.
Madam Speaker, I think that the lawyers who operate in the smaller firms need stronger representation on the council. And I think that there is no strong argument for not having the provision for locally qualified lawyers being on the council. I think there are enough locally qualified that people with relevant experience and knowledge. No, it says 3, right? Madam Speaker, I'll just continue. If they want to stop me on a point of order, that's different. It says 3. I think, in my opinion, all of them should be locally qualified. This is Cayman Islands law that we're practicing, right? No, well, that's what I've been saying. Madam Speaker, I'll try to keep on track because the crosstalk is distracting. Sorry, Madam Speaker, I'm just trying to locate my other section of notes because I had so many that it was difficult to.
You have 1 hour remaining, member.
Thank you, Madam Speaker. I don't think I'll need that entire hour. So, Madam Speaker, the fifth elected member from Georgetown talked about the comments made by Mr. Ian Paget Brown, QC, in his 2013 address. And I think that the point that he made with reference to the concerns he had for individuals practicing Cayman Islands law overseas who, in my opinion, are operating contrary to what the current law says, is important enough for me to give it some emphasis by reading his comments again. But I won't read the entire statement, Madam Speaker, starting on page 6, where he said another way of looking at the expansion referred to in the Law Society's statement is that 12 firms realized how easily the 2 firms referred to were able to circumvent prior to and subsequent to 2002 Cayman Islands immigration laws and regulations by employing persons outside of the islands who did not have practicing certificates but were nevertheless held out as entitled to advise on issues of Cayman Islands law. The 12 decided to join the 2 and have a go themselves to enhance their bottom line by increasing profits by using persons who were not Cayman lawyers to generate fees for them as though they were. The statistics the Law Society provides of 180 lawyers working outside the Cayman Islands as Cayman attorneys, assuming that none of them held current practicing certificates, are generating an estimated US $108 million in fees annually. 180 times the average salary of US $200,000 times 3 times the salary being the expected billings, or a staggering US $1.8 billion over 10 years. Madam Speaker, that gives some scope of how much money is being made in these overseas jurisdictions. So it goes back to my earlier argument that I think the Cayman Islands has missed out on a huge opportunity to be partners in this. And now it seems we're being asked to just legitimize what has been happening. And in my opinion, Madam Speaker, it's time to come to the altar and confess. Madam Speaker, I see this bill as being nothing more than a vehicle for some of the firms to regularize that gray area that they've been operating in for decades. We have a motion, a private member's motion, that is asking for an investigation into this, because we do need to determine one way or the other. And part of that process is what I talk about, coming to the altar. Because it is my opinion, Madam Speaker, that the potential harm to this jurisdiction by operating contrary to what the law says, is even greater than the level of harm that we've been accused of causing. Madam Speaker, no one wants to see the law firms shut down. No one wants to see them go away. We understand how important they are to our economy, to our people. But we have to do it in a balanced manner, and we cannot simply overlook all the issues that have brought us to this point. Without valid practicing certificates, Madam Speaker, those lawyers were never truly Cayman Islands attorneys, in my opinion. The law currently only allows practicing certificates to be issued to persons resident in the Cayman Islands. That in itself, we can't blame it all on the law firms. I understand that. But if we're going to regularize this, if we're going to legitimize this, let's talk about all the other issues that came with it. We've heard comments in the media, Madam Speaker, about concerns with regard to client-lawyer privilege being compromised because of non-Cayman lawyers practicing Cayman law and holding themselves out as Caymanian lawyers, Cayman lawyers. But does that in some way jeopardize client-lawyer privilege because they do not hold valid practicing certificates? Madam Speaker, in my opinion, I don't see this bill providing a whole lot above and beyond what is already the status quo. With regard to the areas of the practice of Cayman Islands law, with regard to jurisdictional protection, education, training, or advancement of Caymanians. I think much more could have been done, Madam Speaker. And I think we have an opportunity still to get those things through. Hence, the over 120 amendments that have been submitted from this side of the House, Madam Speaker. Madam Speaker, I think it would be highly irregular for a company like CUC to propose to take ownership of the drafting of the law that regulates their operations. I think I know the Honorable Minister responsible for that area well enough to know that he wouldn't think that was a good idea. Maybe I'm putting words in his mouth and he will correct me. And then have the individuals who are being regulated regulate themselves. I don't think that would be a good idea, but that is what this bill is seeking to achieve. So, Madam Speaker, I haven't seen the drafting instructions that were produced by the government. I hope they were produced by the government because based on what I know about the process, the lawyers drafted the bill that is going to create a law that will regulate the lawyers. And I already talked about, Madam Speaker, the lack of consultation with the rank and file in the law firms during that drafting process. I know, Madam Speaker, that the Law Reform Commission was not consulted on the drafting of this bill. And I find that highly irregular, given the concerns highlighted by Mr. Paget Brown QC, who is the chairman. And I just don't understand that, Madam Speaker. Highly regarded individuals such as Mr. Paget Brown. How could we go through this process and not consult him? Madam Speaker, this bill is going to legitimize the practice of overseas lawyers practicing Cayman law. And we haven't detailed how we're going to vet those individuals when we grandfather them in. How are we going to assure ourselves that they should be grandfathered in? And in my mind, it's risky to go about it in that way. The only thing we know about those individuals, Madam Speaker, is that they're working for a firm that may be related to a Cayman firm. Madam Speaker, I don't see how this Honorable House can be expected to give blanket approval for a bill that is going to just wipe the slate clean and give the law firms a fresh start without addressing the historical considerations and concerns that have been raised for decades. I don't think that that is a clean start, Madam Speaker. I think we are rewarding them for the times that they did not act in the best interest of this country, this jurisdiction, and our people. And I would much rather see that everybody have a come to Jesus moment and sit down, clear the air, stop attacking each other, and agree to cooperate, ideally. However, one side can't expect to just be pardoned and label the other side as reckless or bandits or whatever it is that they're calling us these days, Madam Speaker. Madam Speaker, this bill is self-drafted for self-regulation, for selfish reasons, and it needs to change. I certainly can't support this bill in the format that it is in. And Madam Speaker, I have refrained today from going into great detail about many, many examples of where these firms have fallen short, because I am trying to be deliberate, but to be reasoned and fair. As I said, they're not all bad. I spent 10 years at one firm, worked with many great people, wonderful people. And this is not an attack on them. The last thing I would do would be jeopardize anyone's ability to earn a living. However, they need to demonstrate the same. Madam Speaker, there is an argument that this bill is going to enable outsourcing to a level that could potentially harm our economy via the lost revenue to the government, the direct investment of having individuals here on island, working on island, investing in the island, the loss of work permit revenues. And I know that the counter argument to that is no, the firms overseas do not employ that level of individuals. But we've seen it happening locally, Madam Speaker, with other industries, where the availability of And I don't like to use the word cheap labor in terms of financial services, but it does exist. There is that temptation. And without strong control on that, any self-serving businessman is going to make that decision that if I can get something done cheaply elsewhere, then I'm going to do that. I think we need to protect against that. If they're practicing Cayman law, then we need to protect that Cayman law. And I don't think this bill does enough of that protection. Madam Speaker, just like other countries who have natural resources like gold and diamonds and so forth, Cayman law is one of our natural resources. It's a precious, precious commodity, and we need to protect it. We can't let others come here, clearly reap the benefits, and Caymanians don't get the same opportunities. I would much prefer, Madam Speaker, and I know the argument will be is that no, we can't push for 60% Caymanian ownership, but it has been decades and decades of Caymanians studying, working, applying themselves, and we're still at the point where we're saying we're still not ready. We're still not able to do it. But if we never set that bar, if we never set that target, we'll never get there. Madam Speaker, every other industry just about requires 60% Caymanian ownership. That's not a sin. There's nothing wrong with that. Every other country in the world seeks to do the same for their people. Why aren't we doing it? This would be the most appropriate time for us to make that transition, Madam Speaker. If we haven't reached the point where we can entrust our future in the hands of our own people, what does that say about us and all this development and progress that we talk about? If we're still not ready to take ownership, leadership, and self-determination into our own hands and move forward together. We all grew up with that in us, Madam Speaker, those of us who are a little bit older, where anything from foreign was better than anything from here. And it has taken us, I still don't think we've done it, but it's taken so long to shake that belief that we are just as good or better. And there come times, Madam Speaker, where you must take that leap of faith and believe in your people. I know it's difficult to balance that with the demands of those who have come here, but we're not asking for anything unreasonable, Madam Speaker. I believe in us. I don't see why the rest of the world shouldn't. So my big concern, Madam Speaker, is that this bill may be setting a precedent for other industries to follow. And I think we need to be careful, Madam Speaker, very careful with how we go about approving this bill in this honorable House. I think it is sending a message to our people that we don't believe enough in them, and that we don't believe the stories that they tell us. And everybody is free to disagree with me, Madam Speaker. But I know through my own experiences and the experiences of many others that there's a lot of truth to what has been said to us. I don't think the sky is falling. I don't think that taking the time to amend this bill, Madam Speaker, and make sure that it is done in the right manner and that our people are the number one priority of this bill is going to bring anything crashing down. We've heard that threat so many times in other scenarios, and we still persevere. Madam Speaker, when our men were going to sea and taking that leap of faith, going out and competing with other individuals from all over the world, and then we started to hear the stories later on of how much they persevered and they excelled. It started from then, Madam Speaker. So we just need to continue that. Continue believing ourselves, determining our future for ourselves, and stop listening so much to those with ulterior motives who come here and tell us we can't do it without them. Because I know many, many Caymanians who can do it. So, Madam Speaker, I look forward to the amendments. I hope that our concerns will be addressed in those amendments. I apologize for the few moments of disruption, Madam Speaker. But I do hope that the government is listening to me today. Let's make sure that we get this one right. Thank you, Madam Speaker.
Does any other member wish to speak? I recognize the first elected member from the District of Bordentown.
Thank you, Madam Speaker. As I listen to the debate and look at the body language by the drafters of the bill, it seems to be some miscommunications or something. It is understandable, Madam Speaker, that those moving the bill will know more of what will come later. My few words is not about the technical part of this bill, Madam Speaker. It's listening on the perimeter of people coming to me, coming to all of us, expressing their concern. The bill as it now stands seems to bring a certain amount of confusion and concern to some of our young Caymanian lawyers. And I will await to hear the close to 200 amendments that may come. Certainly don't look forward to commit a stage for you, Madam Speaker. We have to take turns. But Madam Speaker, like the first elected member for Georgetown going into my 25th year here, this sort of a legislation has been hanging around from time Jesus was on Rivera Beach. What bothers me, Madam Speaker, is the apparent aura of fear from some of our Cayman lawyers whether it's justified or not. Being in cabinet for 3 terms, all of us that stood there at different times had these representations about their concern, what was happening. And as we've heard from my colleagues on this side, the representation from the powers that be, that this legislation is something that should have been looked at long ago. I remember, Madam Speaker, it was last year or the year before, when one of the forums were trying to bring in 3 lawyers to deal with some seem to be minor situations in the case, and they were denied by the Honorable Chief Justice. Whatever the merits were, I do not know exactly. But these are things that I'm sure that draw concern to all of us as legislators when we supposed to have qualified Caymanians here that can do some of this work. Madam Speaker, as I said, I'm not talking about the merits. It's just observations that I make, what I hear and what I see. And I note my honorable colleague, the mover of the bill, the emotions that his face go through when he hears some of the comments made from this side. I pray that when we come to committee stage or when he's winding up, that we all have a better understanding of what's there. We cannot make a mistake on this one, Madam Speaker. I draw an example of when we did the probably most controversial bill, provincial law, the conservation law, when it came to this House. There were dozens and dozens of amendments, but we were all able to sit down and reason, and I know the member from Northside, when we were able to please him on that. It was touching. And I would urge, and I know my colleague, the Honorable Leader of the Opposition, was trying to get us all together to look at this in a committee stage. For whatever reason, that has not panned out. But I will just wind up by saying that when I see that the accounting firms, the elevation they've risen to with our Caymanians at the helm, full partnerships, constantly trying to use young Caymanians. I'm very proud of them. Madam Speaker, I'm concerned of the negative aura that is pervasive around us at this time. Sometimes you can almost cut it like with the scissors. People that call me, Madam Speaker, that message me, that text me. These are just a few comments, real comments, that they say, there is no hope living in this country. They're depressed about the job situation in Cayman, the lack of job security, people losing their homes. Last night one said people are tired of politics. Many residents will not even go out to vote, as they are no longer trust the politicians and our systems. Madam Speaker, am I the only one hearing this? I asked my colleagues, this is Cayman. Need not to tell you what's happening around us in the world. Let us make sure what we do it right. And our priority must be for the Cayman people. Thank you, Madam Speaker.
Does any other member wish to speak? I recognize the honorable member from the District of Northside.
Thank you, Madam Speaker. Madam Speaker, I wish to make a contribution in opposition to the bill entitled "A Bill for a Law to Repeal and Replace the Legal Practitioners Law, 2015 revision, to regulate the practice of Cayman Islands law, both in the islands and elsewhere, to establish the Cayman Islands Legal Practitioners Association, to provide for a system of legal education, to facilitate the entry of Caymanians into the legal profession, and to provide for a mechanism to deal with professional misconduct and for incidental and connected purposes." So, Madam Speaker, I have listened, and I'm not a lawyer. I don't work in the financial industry anymore. But I've listened, I've learned, I've participated by asking questions, by doing my own research. During the last 5 to 7 years in the debate on the modernization of the legal practitioners law. And I've come to one conclusion, Madam Speaker, that this debate, the purpose of this law, the need for this legislation is not about raising the bar of professional conduct, education for lawyers. This is about money, 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 and more money, and who gets and controls the money. Madam Speaker, we only have to look to Schedule 2, Part 1, page 80. Code of Professional Conduct for Attorneys at Law and Law Companies. That's what they say is necessary in order to comply with the FATF and the other international inspectorates that will occur this year. Part 1, and I quote, Code of Professional Conduct for Attorneys at Law and Law Companies. Introduction. The purpose of this code is to provide guidance for attorneys at law and law companies, both of those who provide legal service in the Cayman Islands and those who provide legal services outside the islands. As a guide, not mandatory. There's no code in this that attorneys must and shall subscribe to get a practicing license. It's a guide. They do it or they don't do it. And if you go back to what's required for practice certificate, it doesn't mention code of conduct. Even, Madam Speaker, Part 2 of that, page 121, law firms' best practice guidelines. The Code of Conduct for Cayman Islands Attorneys at Law, the Code of Conduct, provides guidance for attorneys at law with regards to their individual rights, duties, and responsible attorneys at law. To believe that we are drafting a modern law with a code of conduct prescribed in a schedule that is not mandated, is not compulsory, it is not required that lawyers subscribe to it. There are no penalties for not subscribing to the code. And Madam Speaker, while I am not a lawyer, I have a few friends in high places who are lawyers. And I asked for their professional opinion as to whether the bill before this House, would in fact likely to provide compliance with the FATF when we are examined. And here is their response, Madam Speaker. Our professional advice on FATF compliance indicates that the LPB, Legal Practitioners Bill 2016, would not, in fact, be likely to be found to be in compliance with FATF recommendations. And it falls severely short of meeting such recommendations in a number of areas, include failing to provide an independent regulatory body, since the bill purports to create the Legal Practitioners Association by a form of amalgamation pardon, Madam Speaker. Areas, let me start over, Madam Speaker. Our professional advice on FATF compliance indicates that the LPB 2016 would not in fact be likely to be found to be in compliance with FATF recommendations, as it falls severely short of meeting such recommendations in a number of areas, including failing to provide for an independent regulatory body, since the bill purports to create the Legal Practitioners Association by a form of amalgamation of the CBA and CILS, which for all purposes are subject to conflict of interest in regulating the forms, which they also lobby for, as well having provided for a loophole with the Code of Conduct, which allows the conduct to be mandatory by choice. If our government is serious about complying with the FATF standards for the effective supervision and monitoring by the Council of the Legal Practice Association as a self-regulating body before the CFATF visit in 2017, they should agree to amend LPB 2016 and for the provision of effective rules. This includes the amendments to the composition of the Council and the requirement for foreign attorneys to hold valid overseas practice certificates in the jurisdiction in which they reside. Furthermore, the bill would need to provide for ongoing supervision and monitoring in foreign countries with the cooperation of the competent authorities regulating lawyers in those foreign jurisdictions. The argument that the LPB 2016 must be rushed into law for FATF inspection requirements therefore does not hold water. And Madam Speaker, they also supplied me with information which I won't bore the House with about what the prevention from money laundering and what all these things mean and how CFATF does their inspections as background information to support their statement. Now, Madam Speaker, if we combine that opinion with that of Mr. Ian Paget Brown, and this document has already been tabled by the fifth elected member from Georgetown, so I don't think it's necessary for me to table it again. I'm quoting for the documents that he tabled. Which was his address to the Grand Court on January the 16th, 2013, as chairman of the Law Reform Commission, having been requested to do so, I believe, by the Attorney General. if we look at page 4 of that document, Code of Conduct, while on the subject of rules of professional conduct, your lordships will note that the draft rules circulated last month are based on the American Bar Association model rules. It was felt that the ABA code is a good starting point for a fused profession. Where it can be improved, we welcome suggestions. The rules are up to date and reflect the challenges and opportunities of today's global legal environment. The latest edition was published in September 2012. The ABA Center for Professional Responsibility advances the public interest by promoting and encouraging high ethical conduct and professionalism for lawyers. Over 400,000 lawyers are bound by them, and there's a wealth of published material to teach and enforce them. Madam Speaker, that code of conduct that was proposed by the group, including the author of this document, was eventually rejected by the Law Society and the Cayman Bar Association as part of I think it was an option 2 of draft legislation, because it was too stringent, too onerous, too professional. Again, Madam Speaker, I get back to what I see, what I have learned as the purpose of this bill. It's about money, 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 and more money. And my grandmother told me money is the root of all evil. The big boys that receive the lion's share of the money, in the millions annually, have held this law hostage to their economic control, insisting that outsourcing be legalized. And Madam Speaker, every time a draft of this law has been brought up, that was the sticking point. Who is going to be in control? Now, Madam Speaker, when it comes to this outsourcing, I call it, and you know, Madam Speaker, this is a new trend for Cayman. Every other time that I can recall that we have passed legislation to introduce a new product or a new area in the financial industry, the objective was always to move the people on island, to practice on island, so that the island's economy benefited from the money that they made, because they would spend some of it here. But here, this bill is reversing that trend. We are sending it overseas with the hope that they will send some of it back to us. Madam Speaker, I don't believe that's a good plan. But Madam Speaker, on the one hand, and I'm not an economist, we are being told, and particularly the 4 of us in this southeast corner, are being chastised and ridiculed by these people because they tell us these people are not practicing Cayman law. They are just there sending business to Cayman. And we need them to be there to do that, because the old system on which the financial industry was built, and remember when we started this at infancy, we had to wait on airmail letters. I challenge you, and you go around town, they didn't find an airmail envelope. But that's how the industry built. Then we went to FedEx, right? And you got 1 day, 2 day delivery. Now, in today's technological environment, where anywhere in the world, to anywhere else in the world, you can make instant facial contact with somebody through various electronic means. We must have these people over there sending business to us, but they're not practicing law, so they're not doing nothing wrong. So they don't need a practicing certificate. But yesterday, Madam Speaker, the Minister of Financial Services, in moving this bill, said that there are 200 persons practicing Cayman law overseas. But Madam Speaker, I ask the question, how can they be legally practicing Cayman law if they don't have a practicing certificate issued by the Chief Justice on our Code of Law? And because, Madam Speaker, part and a requirement, and a very important requirement of getting that practicing certificate is you must be resident on the island. So, we're admitting that they're practicing law. We're admitting that they don't have practicing certificates because that's impossible under the current regime. But they're not doing nothing illegal. And they're not doing nothing wrong. But yet, we have held this bill up for 12 plus years on that one thing, that they must be able to issue practicing certificates for persons not resident in the island. And this bill specifically provides it. Page 47, Part 7. An attorney at law shall not practice Cayman Islands law, whether in the islands or in another jurisdiction, if the attorney does not have a practicing certificate that authorizes the attorney to practice Cayman Islands law. And Madam Speaker, there's another section, starts on page 39, section 31.1. To be admitted as an attorney at law, a person shall, A, be a Caymanian, B, hold a current work permit or a residence and employment right certificate, or otherwise be entitled under the immigration law 2015 revision to reside and work in the islands as an attorney in the capacity in which the person is or is to be employed by the government, or be ordinarily resident in another jurisdiction, and be a partner, director, member, or an associate or employee of a qualified firm or an affiliate of a qualified law firm. So, now that they're getting that expressly provided in the law, if you no longer need to reside here, they're happy. They're spending thousands of dollars taking out ads and putting the picture of 2-3 little Cayman lawyers in CUFs, Caymanians up front, that they promoted it, put out there. They said, oh, this is a great thing. Caymanian up front. Madam Speaker, let me make my position clear. I don't agree with anybody practicing law outside of the Cayman Islands. That's my position. And I have been advised by very serious counsel that the financial industry does not require it. This is just a method that they have developed, which is convenient for them because it bypasses our immigration law. They don't need work permits, and they start getting too many work permits. You hear then they're not giving Caymanians enough opportunity, and some of them people on the board might get upset and turn down their work permit. But if they send them to Timbuktu, we're not going to control all that. Madam Speaker, we are so worried, or not me, because I don't support the period, but the drafters of this legislation, the government sponsoring this bill, is so concerned that they're not going to be fair, that they have put in a numerical formula for them to follow. Just think of that. We're supposed to be talking about professional people, lawyers. That makes him better looking. Madam Speaker, why? We are told that because we're in this global environment now, people can't wait anymore to get on a telephone, either Skype if they can't afford to pay, or video conferencing to talk to somebody in Cayman practicing Cayman law. Got to be instant. Got to be in their time zone. Easy to be in their time zone, Madam Speaker. All we need to do is open your office in Cayman 24/7. Employ some more Caymanians in the lower echelons of your office. Administrators, telephone operators, etc., etc., etc. Support staff. That's good for the country. That's good for the economy. Licensing attorneys in Hong Kong or Singapore, now help us. What's to stop them? How do we know that they're sending business to Cayman and not to the same law firms here that are sponsoring offices in BVI or TCI or Bermuda or somewhere else? There's no requirement here that any client that they advise on Cayman law must send the business to Cayman. Because that would be an impossible thing to put in the law. Now, Madam Speaker, we have been chastised because we're threatening the financial industry, because we're asking certain questions. Now, Madam Speaker, I wonder which scenario the government would prefer. We ask the questions, we expose the wrongdoing, we clean up the mess. Or the authorities in Hong Kong, Singapore, or Dubai find out that something wrong is being done as a possibility. They have been told that somebody practicing Cayman law in their jurisdiction has a practice certificate, and it turns out he doesn't have one. And they make a big international scene out of it. Is that the scenario that the government believes will help us with OECD and FATF and CFATF and all these other things? It has to be better for Cayman to conduct the investigation and find out if they've been breaking our laws and punish them according to the law. Because we can brag about that to the OECD and the FATF. We're cleaning up our house. But no, they prefer to turn a blind eye. And they have been ignored because, Madam Speaker, I have serious problems with what the law Reform Commission chairman state, before the grand court of our law. And no action was taken by the supervised authorities. He just let it grow. Two firms. Nobody said they were doing it wrong. The other companion firms around town went along. If you can do it, I can do it. And they all opened offices, and they all hired people to practice Cayman law without practicing certificates. And now, because there's so many of them, it's like the financial meltdown in the United States, 2008. They're too big to fail. They're too big to fail. But Madam Speaker, now you know. My father in Northside, who picks up 12 conks on Saturday to feed his family because he didn't get into work that week, he couldn't go to the supermarket to buy food, pork chops. The Marine Conservation Officer catch him with the 12 conks. They take him boat, they take him trailer, they take him boat engine, they take his snorkels, they take his fins, they take his goggles, and they can fine him up to $500,000. And they take the conch from him too. And then they invite their friends over to have dinner. Oh, I know. But they like lobster more than conchs. That's more impressive. So, Madam Speaker, do my people who break the marine law have an expectation to be ignored until enough break it and then we come down here and change the law? That's what we're doing for the lawyers? But that seems to be fine and dandy. Madam Speaker, I offer them no sympathy. They broke the law. They must pay the price. But I want the same thing for these other people that are breaking the law. Laws in our country and the enforcement thereof should have no relation to income or the position of influence in politics and economy that you may control in the island. That's what I support. But in this case, when all the other law firms found out that 2 was doing it, the other 12 joined. And we said nothing. We did nothing. Madam Speaker, you're here, I'm running around here about nobody complained. Madam Speaker, I personally wrote a letter to the DPP 2013 after I heard the speech and asked that they investigate this thing and prosecute those who were guilty or were suspicious of being guilty. The first response I got was, it's not the DPP position to discipline lawyers. That of the Chief Justice. So I responded, I'm not talking about discipline. I'm talking about criminal prosecution under Section 10. And I laid out the cases put forward here and other cases that some attorney friends made me aware of. And I got back a letter saying it was being referred to the Chief of Police because they don't think I had put forward enough evidence. February 2013. My grandmother said, and I heard teh since. But when the little Caymanian get catch with one spliff of ganja, they ruin your life forever. But these people are too big to fail, too big to be investigated, and to be prosecuted on the suspicion of breaking the law. Now, Madam Speaker, the other reason that the move of this legislation says it is necessary to amend this legal practitioners law is because the law is a 1969 law, and it is so antiquated, and so backward, and so unfit for today's legal environment. You know, Madam Speaker, I asked the staff here to get me the most recent legal practitioners law. They gave me a 2012 version, but I see the title of this refers to replace and repeal and replace the legal practitioners law. 2015 revision. That makes it even more modern, unless this is a typo. But, Madam Speaker, unlike what they're telling the public, this legal practitioners law was not passed in 1969 and forgotten about. On the attorneys urging, lobbying, and requests, the legal practitioners law 1969 has been amended 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 times. But all of them, I'm so disappointed that the chairman of the president of the Law Society only has the 1969 copy. Some of his friends did tell him to come down to the LA and ask for the most recent copy. That's all he talks about. 1969 law. Huh? He has some funny name like that, yeah. Madam Speaker, Law 4 of 1980 was amended 17th of March 1980. 19th December 1982. 24th of November 1983. 9th of May 1984. 21st of May 1986. 29th April 1987. 8th of July 1996. 15th of February 1999. 26th of September 2001. 19th December 2002. 31st July 2006. 21st October 2009. 3rd of August 2011.
Member from Northside will take the afternoon break at this time.
Thank you, Madam Speaker.